I begin in the name of God who is most beneficial, most merciful. I am out of breath. Nick Kidwai, resident of Newbury Park, Director of Concerned Citizens of Thousand Oaks since 1993. I guess this will be a quick meeting, 20 minutes like the last one. I would like to ask the chair and other people, why do we have the cameras here turned off? I mean, we are paying a ton of money to have it, and the traffic commission meets here. They work. Why is it that you don't want taxpayers to be involved and know what's going on? Why is it that you have to have it at this meeting at 3 o'clock? I mean, even Glendale, where one of your planning commissioners is from now, they have their meetings in the evening. And that's why I'm running, because I had to fight fires at work, and I could not. I had to abandon that to come here to a 3 o'clock meeting, and other concerned citizens, taxpayers, want to be involved in this. And I wrote to them, and they wanted to come, but they said, sorry, cannot take time off at the middle of the afternoon from work. One of the issues that is not on the agenda, which is very important, is that you had purchased properties on the west side for almost close to $5 million. And one of the staff members told me that will be coming on later on, but I would like the Department of Finance and the State Controller's Office to take action on it as soon as possible, because this was basically a blatant attempt by the city to reduce the account, the money that you had in the account, so that it would not be turned over to the state. In closing, I would just like to say that I enjoyed that your paid staffer made kind of fun of me that I had referenced AB 27 when I had mentioned AB 26, and I don't know, I'm not a professional, I'm just a taxpayer, and he knew exactly what I was talking about. But the sad thing is that no one on the dais that is representing the taxpayers, we have a public representative over here, no one challenged the staff member, the consultant, to answer the question. Thank you for letting me speak. Without a card, I will fill the card. Thank you, sir.
Thank you, Mr. Kidwai. Action items, item 7A is a report by John Adams, our finance director.
We hand out copies. Actually do a presentation. This helps me walk through the ROPS. Good afternoon, Madam Chair, Oversight Board. In front of you today is the ROPS 4, or better known as ROPS 1314A. So I handed out just a quick PowerPoint. I have 8 slides I'm just going to walk through briefly. So just talk about the new format, what's on the ROPS, talk about the reconciliations, try to walk you through, and then ask you for approval on the resolution for the ROPS. So just a quick intro. The ROPS is covering and I should clarify, ROPS, Recognized Obligation Payment Schedule, is covering the period between July 1st and December 31st of next fiscal year, or calendar year 13, or the first 6 months of fiscal year 13-14. It's due to the DOF by March 1st, and that's why it's on today's agenda. And then it should be reviewed and responses by the DOF by the 15th of April. On slide 3, DOF continues to revise the forms, in their opinion, improve the forms. So it's a 5-page format. We have a cover, which is on page 8 of your packet. You have a summary, which is actually a very simple summary to show the amount available. And that's on page 9. The tax is collected from the redevelopment property tax trust fund, and then sort of the obligations and the distributions. The third item is the actual listing of the obligations, which is on page 10. On page 12 is actually I'm sorry. So I'm on slide 3. When I'm referring to pages, it's actually what's in your packet. So prior period payments is actually a reconciliation between a prior period, and the period that they're looking at is July 1st through December 31st through calendar year 2012. And then the last part of the new format is actually notes, which starts on page after 13. So on slide 4, I'm just going to talk about the changes from the previous ROPS. There are 2 new items, and one of them on slide. Okay. Changes from previous ROPS, new items. One of the things we added, and which is going to be occurring over the summer, is an asset management plan. Staff is anticipating costs up to $50,000, whether it's doing appraisals for the properties or doing other research on that asset management plan. The other item is the auto mall. The DOF's new ROPS does not allow you to add things, or you have to add them at the end, and they actually highlight or gray out areas that they have determined or have rejected. And so staff is reapplying or re-adding that item to the ROPS. That goes into the denied items. One of the denied items that we've discussed was the housing monitoring costs, which was $137,000, the auto mall, and then the Discovery Center of $5 million. And then revised items. The difference between previous ROPS and this ROPS is legal counsel fees were an expenditure from the trust fund. It's included in the admin cost now. And then the other one is the chapel loan. One of the items that's on tonight's or this afternoon's agenda as item 7C is the approval to make payment for the chapel loan ahead of time. Okay. So moving on to slide 5, I'm sorry. The reconciliation. Slide 5, we just simply say that the reconciliation, that is the fourth part of the ROPS, really is reconciling expenditures from July of 2012 to December of 2012. There is no adjustment to the distribution, but if there was a difference, there would be an adjustment. And then slide 6, the notes that are on, well, starting after page 13, just highlight what each ROPS item is. Okay. So with that said, on the last page of the presentation, slide 7, the timeline, as we talked about, board approval today, submittal to the DOF by Friday, DOF review completed by April 15th, meet and confer process, if that's required, would be within 5 days, and then the distribution from the tax fund would occur June 1st. That would help us pay for those obligations starting July 1st through December of 31. And then the next process would be ROPS 2013-14B, which would need to be submitted to the DOF in October, which would mean that we could probably be back in front of the board in September with those obligations, and then review and then meet and confer and then the distribution for the next 6 months after that. With that, I'm available for any questions, and the recommendation from staff is approved resolution.
Ms. Burns?
I have a question.
Sure.
So the auto mall and the Discovery Center were both denied by Department of Finance from prior ROPS.
Yes.
Okay.
From the last ROPS.
Okay.
But the difference is Discovery Center was denied multiple times. The DOF approved the auto mall on ROPS 1 and 2, and then came back on this ROPS and said, ROPS 3, that it wasn't.
Okay. And if I recall correctly, there is a contract with the auto mall?
That is
Or,
correct. There's a funding agreement. There is what we believe is an enforceable obligation. Yes.
which is in the form of an agreement
Yes.
with the auto mall, but not with a general contractor?
Correct.
And that's the basis by which we're proceeding to define it as, the city's defining it as an obligation.
Correct.
Okay, and the Discovery Center is now off.
We're not contesting that anymore. The board has given us latitude to apply multiple times on the ROPS. We've gone through it 2 times. Staff is now recommending including that as an obligation going forward.
John, 2 questions on the auto mall.
Sure, Dr. Karstead?
The contract with the mall owners preceded the whole redevelopment legislation?
Yes, it was an obligation entered into early in 2011. So prior to the dissolution act, the budget that was in June of 2011.
And the DOF maintaining it because you didn't have construction contracts in place to do the work they're disallowing?
You know, I'm going to defer this to the city's assistant city attorney, who has been a lot more in-depth with the DOF on their basis for that.
Actually, that was their original argument in the first letter denying it. When we did the meet and confer process, they sent a final letter and they changed the rationale. They claimed that the agreement by its own terms terminated a year after it was entered into. We disagree with that analysis, and at some future date, staff may go into closed session with the successor agency to determine whether to pursue litigation on that determination.
Okay. Other questions? Concerns?
Sorry, the Kelly Road improvements, those, what did the DOF do with those again? Sorry, I know this is old stuff, but it's
I haven't seen it
been
for
a little bit of
Where do you
time.
see that?
So it was on the 2012 ROPS.
Oh, yes, I'm sorry. You're, okay, I'm trying to get caught up. There were, in the 2012 ROPS, we included projects that were funded by bond proceeds. So there was 2 specifically that were identified for bond proceeds. One was the undergrounding or bond proceeds used for undergrounding on Thousand Oaks Boulevard, which was part of that project area. And then Kelly Road was bond proceeds for the improvements on Kelly Road. So they came back and said, you do not have enforceable obligations. That was then 1484 came and said, if you get your golden ticket, you can use these these unspent bond proceeds. So those are why those projects would not be on the most current ROPS, or that we're not contesting those yet, because we don't have to turn those bond funds over as part of the due diligence review and receiving our golden ticket. Does that hopefully
Okay, so
clarify
then
that?
the question is, those projects which we now think are allowed will be under 1484, but they're not on the ROPS because the obligation isn't there yet for the
Correct.
construction work for that.
Correct, and staff, part of the consideration of preparing this ROPS was, do we add those assuming we get the golden ticket or the certificate of completion? And from our perspective is we wait until we get the golden ticket or the certificate of completion, then we go through the process of truly obligating those bond funds to contracts. So you would probably see us come back the next ROPS maybe and include them going forward.
But that would be in 2014 then.
Correct, that would be the first one, yeah.
So it's going to take a year to sit and get clarification or a final approval on
No.
those things?
No, we believe we'll get the certificate of completion within the next couple of months.
So the work is underway?
No. If we're talking Kelly Road or the undergrounding,
Right.
no, because we don't have actual construction contracts.
So when you're saying certificates of completion of,
The certificate, correct me,
Finding
I'm sorry, finding of completion that the DOF issues once we comply with certain components of 1484. Yeah, and I'm sorry, I confused the certificate of completion with the finding of completion, which is the golden ticket.
Okay, so we're thinking it's gonna take a whole year to get a final,
No, golden
Whatever
ticket.
you-
Gold,
yeah,
let's,
that-
let's call it the golden ticket.
that golden ticket thing?
We would
It's gonna take a whole
expect-
year to get that from DOF.
No, we would expect to get the golden ticket within the next 3 months.
And then would
Correct me
we,
when I'm wrong.
would we amend the 2013 ROPS to then include that?
No, if you look from a time, give me some latitude, and Chris and Mr. Norman and Mr. Prescott will clarify. We would see the timing of, we get the finding of completion of the golden ticket within 3 months. And there's some things we have to do as part of that. We would get that. Then we have the ability to start planning to spend those bond proceeds. But we're not gonna include them and spend the money until we actually go through the process of identifying what the how the improvements are going to, and to execute agreements. That's the other thing. Even if we wanted to do the undergrounding, and that's what the purpose is, it would take us several months to finalize the agreements with Southern California Edison, get all that in place, and in theory, we wouldn't be ready to spend anyway for 6 to 9 months. So, I mean,
So we weren't, I mean, the city wasn't ready then to go ahead with I don't know what the original timeline was on those projects. Obviously, they're delayed now. I mean, my issue, if you will, is that the redevelopment is supposed to start winding down. And yet here we are now delayed in part because we need this golden ticket thing and the whole RDA business. So obviously, I mean, that's a true delay. But we obviously didn't have then the permits, all the engineering and everything in place except for maybe a construction contract.
I would say that if the elimination of redevelopment did not occur, the underground would be far through the process. And I'm not talking design, I'm talking completion. The fact that the final design, I mean, it's been slowed because of the uncertainty. If you said there was no uncertainty with redevelopment funding, those projects would have been done. Those bond proceeds would have been spent, I'm gonna say, at least a year ago. But when you go back and you look at when the decision was made in June of 2011, which is over 18 months ago, Kelly Road's a great example. That would have been done at least 12 months ago.
I could provide some clarity on both of those, and I think we might have walked you through this before. I apologize if I'm repeating from several months ago. We'll take the undergrounding the utilities on the boulevard. That would have been done. We probably would be out having a official groundbreaking, or not. We've done the groundbreaking. We did the final ribbon, final burial, or whatnot. The delay has been because of the dissolution. And we have the cost estimates from Edison. We had meetings with them last week.
Engineering done.
Yeah, so we're trying to fine tune the project. So that, the AB 1484 allows for that. So we're very confident we'll get the golden ticket.
Yeah.
But the timing though on that, and then the other one, the school district, Dr. Barset could attest to this, we would have, they probably would be leaving the site now at Canal Valley Continuation High School, and those kids would be at a better location, or close to it, we'd have something in place. So we've been put on hold, but we have plans ready to go. We're in negotiations still with the school district. So it's a timing issue. The bonds, we believe, are protected.
Okay, but you still, I mean, the permits have costs, there's other things, even though you may not start construction until January, which is 9 months from now, 10 months from now. I just was surprised, if you will, that those weren't on the 2013 ROPS on the basis that obviously it's still the intention, and under 1484, I think that most of us agree that it's allowable, and yet it's not on the 2013 ROPS.
Because it's too risky. We're waiting to get the golden ticket.
Well, let me give you just, the clarification, and, maybe we can get back to the board on this. We've taken very conservative approaches on this, and putting an obligation that truly doesn't have a contract yet, for the potential of getting the finding of completion or the golden ticket, and we don't have a contract with Edison, don't have the authority to enter into a contract, and if we did enter into a contract, we don't have the access or the true buyout from the DOF to spend the funds on that creates and I understand certainly the dissolution postpones everything, but I'll tell you, if we put on Kelly Road and Teal Boulevard, I can't imagine the DOF wouldn't reject those and say, you don't have obligations, you don't have the authority yet, you gotta wait, and you have to step through all this other stuff. And so, I don't know, I mean, if you've been on other boards and they have taken this approach, we certainly would appreciate your perspective on it.
No, I don't, none of the others that I've been on, have a similar situation.
Yeah, I mean, these are unspent bond proceeds. 1484 provides for the ability to spend unspent bond proceeds, but we have to do several things between that point. And in order to get the golden ticket, we're not there yet. But we anticipate getting that within the next 3 months, and then we will start working with the hope to spend those bond proceeds as soon as legally possible. So that's just my name shaped up in
And
there.
then, wasn't there one other project that perhaps was denied? The historical.
Timber School, the historical presentation, and that was given up. I shouldn't say given up, but it was something that we did not proceed with.
Okay.
That was really that and the Discovery Center were denied on the first ROPS.
Okay. I just wanted to remember. Okay.
DOF gave us
Any other questions? And I appreciate the comments. I think that the ROPS going forward is going to be, and this one really only has a couple minor changes, really the property management. The ROPS, once we get into the next time and we have the bond proceeds, outside of that, the obligations are not going to change. It's simply going to be paying off the debt, so to speak.
I, just two things. You wanted to speak on this item, then?
Yes,
Is that what
ma'am.
this said? I can't read. Okay, and then, so basically, they've denied the auto mall request twice. Is there, okay, well,
Just once.
yeah, I.
approved it twice.
Approved it twice, denied it on the
Well,
most current
yeah.
one.
I mean, I can kind of look at it as twice. Now, I think I understand the strategy for putting it back on, but are there any negative outcomes from continuing to put it on, or is it just that it would be denied?
No, I think all they could do is deny it.
Yeah, and,
It's not like they can start.
They should
to
slap
track
you.
that away,
You can't
yeah.
punish the city for that.
no.
Just don't know what
At
they're
least-
doing
at
if
least
they're.
not
Yeah,
explicitly.
my only concern was that if it's not on there, then you can't enter into any contracts until 2014.
You're talking Kelly Road and Teal Boulevard.
Right.
And on the auto mall, I think,
So,
and that's,
I mean, they've been on there before, so to put them on there, unless we can get, it's a ding.
Well,
if
let
we
me
do it.
explain one of the rationales for doing this is,
It's on.
staff has not had a closed session with the successor agency to determine whether to pursue litigation on DOF's determination on the auto mall agreement. Depending on what happens, we may need to do that, and we may want to go to court quickly. There's a lot of litigation going on statewide with these types of determinations by DOF, so we want to reserve the right to be able to go to court, and if the court agrees with us and overturns it, then having it on the next ROPS gives us an advantage in the ability to actually potentially expend those funds during that time frame. That may not happen. We may actually wind up waiting to see, but we like to have that option to expend them if we get a court to agree with our position.
Any other questions?
Yeah, John, a different question, and that's just pass-through agreements. We'll no longer see those on ROPS because that's all been
it's all
approved,
handled.
adjudicated, sent to the county, and now it's the county responsibility.
Correct, in the first, in the first ROPS, especially in the first ROPS, we actually did it, the county took it over. The money that, as you know, that was on trust with the redevelopment agency, the successor agency, was turned over to the school district. So you will not see pass-throughs or any results of those pass-throughs on future ROPS. Those are not obligations, and those are really taken off the top from the county, from the redevelopment property trust fund.
you will not see those.
Thank you.
Mr. Kidwai?
Nick Kidwai, resident of Newberry Park, Director Concerned Citizens, Thousand Oaks. First of all, I would like to just say that the taxpayers would be very upset if the city or the board decides to spend more money in lawsuits, especially when they are frivolous. And this auto mall contract, not only does it is it outside the preview of the redevelopment agency laws, but the contract itself basically had been violated. And you don't need you need a high school education, you don't need a college education to understand that. I am sending a letter, finally faxing it to Governor Brown and also to Mr. Chiang regarding these issues, and I've been told that there's more action if you do that rather than email. I do apologize to the DOF and these are the people if they end up watching this hearing on YouTube because you know, at 3 o'clock for working people it's just they have succeeded. That's why it's empty, even the reporters are not here. I have given you 2 pages which I could not print more regarding what I am sending, so I would start by reading that the 7A, we would like you to deny number 15 and 16, which is the TO Pass agreement, and it is not valid. Dr. Barstad, I've been talking about this for 20 years, and so have other conservative people in this community. The background is that this was enacted because the ERAF, Education Augmentation Fund, after Proposition 13, took away the school money, and the City Council decided that, well, we want to help our children, so they did this agreement, but then the ERF was backfilled by the state legislature. So this has been a double dipping. I've been talking about this for a long time. Double dipping, it's like a double dip cone that the school district has been getting. And the whole idea, and the board seems to have lost track of this, is the whole idea redevelopment agencies are no longer existing. They are supposed to be wound down. The party is over. The party is over. How many times do you need to listen to that? Thanks to this legislation and other things that the good governor has done, that California is on the mend. It's coming back. It won't come back if you keep doing these things which are bad for the economy, which are bad for the taxpayer. And the governor has also ordered that the money should be going to more needier students, and we are affluent. I just read about the iPads that our students have, which is wonderful. There are students in Compton and El Monte and La Puente that don't even have books. I mean, so that's where the money should be going. And, you know, people say, well, Mr. Kidwai, or concerned citizens, I mean, this money, and that's been the thing, is that it's free money that's coming to our kids. There ain't no such thing as a free lunch. I would like to draw your attention, and I'm surprised that nobody has mentioned this, because you have the packet in front of you regarding the Westside property, which is, I think, number 16 and 15 on the ROPS, that the rent is $932 a month for those 3 businesses. I mean, what kind of a scam is that? I mean, this should be eliminated. So that's why that's the whole purpose of this legislation, was to wind down these things, stop the losses, and sell these assets which are a money loser, rather than having the taxpayers subsidize that. Thank you, and I would like to speak on the next item too.
The recommendation is to adopt the resolution approving and certifying the July 1st through December 31st ROPS. Do you have a motion?
Jack, I'd like to move we adopt the resolution.
Dr. Barstad, second.
Sure.
Mr. Shortheimer, Mr. Watkins. Any, all in favor?
I just want to make one comment. I applaud the city and for continuing to pursue the money for the auto mall. Money belongs to this community. I think that when you say yes twice and no once, it's arbitrary and capricious, and I, for one, would entertain any information you want to give us in closed session someday about litigation if it's denied again, and if in the opinion of legal counsel there's some action there.
Any opposed? Item 7B, Mr. Prescott.
Okay, the second item on your agenda is a request from the successor agency that the Oversight Board authorize the transfer to the city of Thousand Oaks of certain property that the successor agency owns, former redevelopment agency property, that is used for governmental purposes. And I think the board is fairly familiar with this topic since we did bring the list of assets to you. I think it was back in the early days of the board, maybe in May or June of last year. And we have a resolution which has information about each of the assets. There are land assets, there are buildings that are located on land that is owned by the city, and there are infrastructure improvements which are basically, from an accounting or bookkeeping standpoint, they're booked as redevelopment agency assets, even though they're indistinguishable from, for example, city streets. They're street projects or other projects that were done using redevelopment agency money, but they're part of city public streets. Just to highlight, the land involved includes the Arroyo Caneo Greenbelt Walkway. That's between Moore Park Road and Boardwalk, north of Thousand Oaks Boulevard and south of Hillcrest. And that's also not only land, but some of the improvements there. And it's actually a portion of the land and a portion of the improvements because the city itself did fund a portion of that project. Then we have the Zuniga Ridge open space that the redevelopment agency received from a property owner whose development on the property was assisted in a rehabilitation project by the agency. Heritage Park, located on Thousand Oaks Boulevard at Moody Court. And then the buildings here at Civic Arts Plaza are owned by the successor agency as former redevelopment agency assets, and those include the two theaters, the parking structure, and the city hall. I'm sorry, just the theaters and the parking structure. We also own the child care building, or at least a portion of it, because it was originally acquired by the city. The redevelopment agency made improvements to it and expanded it. This is the one on Caneo School Road. There are also tenant improvements, a small amount here at City Hall that were funded by the redevelopment agency to provide office space for redevelopment staff. And then we get into the infrastructure improvements, and they are basically different projects within the Thousand Oaks Boulevard redevelopment project area. There's one within the Newbury Road project area where the agency funded street improvements, sidewalks, streetscape, etc., and some improvements here at Civic Arts Plaza. So that is the list. The state, I've attached an exhibit that shows the sequence of events, and I apologize that it didn't print out very clearly, but the state really does allow the transfer of assets that were owned by the former redevelopment agency that are used for governmental purpose, and all of these do qualify, to the governmental agency. And that's what we're asking you to do here. We have not included other assets that the agency owns that are not used for governmental purposes, and those are specifically the Westside properties that Mr. Kidwai spoke of, and also the Lakes property. The agency owns the successor agency owns the land under the lakes. The developer owns the improvements. Neither of those two properties are used for governmental purposes right now, so they don't qualify for a direct transfer. They instead will be addressed in the long-range asset management plan. And to refresh, once the redevelopment agency or the successor agency gets the finding of completion from the Department of Finance, meaning that we have identified and turned over all of the money in our bank accounts that's not necessary to fulfill obligations. Then we will get a finding of completion, and at that point we'll have 6 months to prepare an asset management plan. And there's different options for the properties that are covered by that plan. Some may be eligible for transfer to governmental agencies, others may be sold, others may be leased, whatever. That's all going to be developed in that plan, and that would deal with those 2 properties. But all the other real property assets and infrastructure that the agency owns are used for governmental purposes, and they qualify for transfer, and we're asking the board to approve it at this time. And this, again, is subject to Department of Finance approval.
Mr. Prescott, questions? Mr. Wilmer?
Is there any requirement that these maintain their public use status? Some sort of restrictions that are placed on the properties?
I'm not aware of any such restriction in AB 1484 or AB 26.
Has the city been, and is it projected that they'll continue to have the resources to be able to do the maintenance on the Civic Arts Plaza and the Child Care Center?
Yes. The agency doesn't maintain property. The redevelopment agencies are only allowed to spend money for capital improvements and acquisitions, et cetera. They're not allowed to spend money on maintenance. So all of these facilities are currently, to the extent that they're owned by the city, are maintained by the city already.
Is it conceivable that at some point, which this kind of follows up with your question, that the city could decide to, 10 years from now, that it doesn't want to have the child care center, doesn't need it, doesn't want it, whatever, and then chooses to sell it to a developer for something else? Are they, I think what I'm understanding is they're allowed to do that.
Yeah.
There's nothing in the law that prohibits what the city would do after acquiring those properties.
Okay, and then that money obviously goes to the city, because we
Right.
transfer the asset to the city.
Correct.
We'd also have to change the zoning.
Well, and let me clarify specifically on the childcare, because that is, let's say it is possible. The RDA built or made the improvements to the building. The actual land is actually owned by the city, if I'm not mistaken, Mr. Prescott. So, if, again, the building is being used for childcare, if it was sold to a developer, I'm not sure that they would want to run a childcare facility.
How do we release that property?
We actually have an amazing agreement with CDUSD, who runs the program and does a great job. So we're very happy with that.
And I'd add the city, city applied for and has received for years a really generous state child care grant. So this subsidizes the child care of about 200 kids every year.
About 600,000, and it's been a great relationship.
Very, very
So,
successful collaboration.
yeah, I mean, there's always that possibility, but it's certainly not the intent of us transferring it and doing something with it, especially when the land is owned by the city anyway.
Yeah, I guess because it's only the improvements.
And even on the buildings as well. When you look at the other improvements, the land is owned by the city, so, for what it's worth.
Mr. Kidwai?
Nick Kidwai, resident of Newbury Park, regarding 7B inventory number B1A, Cavalier and Share Theaters. It will fall on deaf ears, but I would ask for a denial of this because one of the problems with this agency is that the history is never mentioned. There was strong opposition to building these theaters. The basis of building these theaters was one ballot measure that said no taxpayer dollars will be used. And for the life of me, I can't understand how the Kavli could be a government use, because it's used for the arts and for private businesses. Share has a few city council meetings. The really sick thing is that it's on page 39 that $1,685,000 was spent from the general fund. And then we even have wastewater funds of 194 and solid wastewater funds. I thought that the juggling act had been over and that these funds had been transferred back. So I would like staff to answer that, if that is still owed to the general fund, or that is just a historical fact. The denial is not capricious, with all due respect. The DOF is is based on professionals, unlike some people that I know, and they have acted in full within the law